powered smart speaker, and on TuneIn, iHeart, and on Odyssey. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan, and in for Amy J this morning, former ABC 7 political reporter Charles Thomas.
I have enjoyed this week, Dan.
It's been great, and we've loved having you. It's been a lot of thought-provoking conversation, and we appreciate it. And, of course, with the momentous decision by the Supreme Court yesterday, we've had a good old time poring over it today. Here's Chief Justice Roberts' key phrase in his majority opinion, striking down race-based college admissions in the Students for Fair Admissions v. Harvard College case. The Harvard and UNC, Harvard and North Carolina, admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives, warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions programs to work in that way, and we will not do so today. Eliminating racial discrimination means eliminating all of it, wrote Roberts for the 6-3 majority, 6-2 in the Harvard case because Kagan recused herself. The big guy, Mr. 10%, responded thusly to the decision and immediately.
Let me say this again. They should not abandon their commitment to ensure student bodies of diverse backgrounds and experience that reflect all of America. What I propose for consideration is a new standard, where colleges take into account the adversity a student has overcome when selecting among qualified applicants. Let's be clear. Under this new standard, just as was true under the earlier standard, students first have to be qualified applicants, because the truth is, we all know it, discrimination still exists in America. Discrimination still exists in America. Discrimination still exists in America. Today's decision does not change that. It's a simple fact. If a student had to overcome adversity on their path to education, the college should recognize and value that.
Setting forward a way to end run in case Harvard and other colleges needed any help, really, from President Biden, but setting up an end run around the counting by race that colleges and universities do as a matter of course. For more on the legal implications of this decision, pleased to be joined by the famed Harvard Law School Professor Emeritus, author most recently of Get Trump, The Threat to Civil Liberties, Due Process, and Our Constitutional Rule of Law. He is Alan Dershowitz, and you can get his podcast, The Dersh Show, on Spotify, YouTube, and iTunes. Professor Dershowitz, thanks again for joining us. Appreciate it.
Well, thanks. I have no problem with the words spoken by President Biden. I think he's right. Schools can and should take into account individualized handicaps that have been overcome, individual situations of discrimination based on gender, race, or physical inabilities, etc. The problem is the schools will probably use that as a loophole through which to drive a whole football stadium of exceptions. And they're going to stick to what the Supreme Court found were essentially quotas. And when you have quotas, usually you have two elements to the quota. You have floors. That is, you never have a class with less than 10, 11, 12% African Americans. That's the floor. Then you have ceilings. You never have a class with more than a certain percentage of Asian Americans. And it was both the floor and the ceiling, but particularly the ceiling on Asian Americans, which caused the Supreme Court to come to the right decision, a decision that's been criticized by a lot of liberals, but it's a liberal decision. That's the point. It's the same view that Justice William Douglas, perhaps the most liberal justice in history, took back in the day when race-based affirmative action was still first being proposed. He said there should be affirmative action based on individual qualifications, not on racial characteristics. You don't want a situation where the wealthy child of a African American mother who's a hedge fund person and the father who's a federal judge, but who has lower grades, to get an advantage over a kid from the Midwest whose mother died of fentanyl and who's gone through terrible, terrible situations, but who has better grades. You don't want race alone to be a determinative factor. So I think that what the president said was right as long as it's used correctly, but I have my doubts about whether it will be used correctly.
Why were the military academies exempt? Not that not that Thomas was on board with that, but yeah, it didn't. That I don't understand that.
I don't understand it. It probably was necessary just to get a majority. It's one of these compromise things. Somebody on the court says, no, I'm not going to do it for military academies. I just don't understand the reason. One of the first integrations that occurred in the United States prior to Brown versus Board of Education was the decision to integrate the military during the Second World War and post-World War II, and that worked very, very effectively, and that has to continue to be the same. I don't think that military academies should be able to discriminate.
Right. I mean, in their amicus brief, they essentially, which Roberts referred to previously, not in this case, but they essentially said, for an increasingly diverse corps, we need an increasingly diverse officer corps. And that sort of sounds to me like, we need black officers to lead black enlisted. We need white officers to lead white enlisted. I thought the whole point is to get beyond that, like we actually have in reality.
I think that's true. My two mentors in college and law school were Telford Taylor, a former general of the United States Army, the chief prosecutor in Nuremberg. Nobody could be more waspy than that. And John Hospers, who was a great professor and a libertarian. They were not Jewish. I didn't need, even as a kid, a Jew to be a mentor to me or a role model for me. I like people being role models based on, as Martin Luther King would put it, the content of their character, not the color of their skin. And I think the same is true. We don't want to encourage people to have role models based on race alone.
What do you think the implications of this case are with respect to litigation in the private sector or in K through 12 education with affirmative action and other race-based policies?
Well, it's going to be interesting because, any institution that takes federal funds, which means every university basically, is bound by this decision. But, private elementary schools are not, and many other private institutions are not. And so there'll be legislation. And the legislation is subject to constitutional analysis. So it's a work in progress. We'll have to see what happens.
With respect to one other topic before we let you go, all things Biden Inc. related, the whistleblowers from the IRS, one who's come forward and the one who hasn't, and all the detail that's been provided, and the mutually exclusive statements that have been made by the whistleblower and documented as compared to Merrick Garland per his involvement. If you're looking at this, do you see the real possibility that President Biden will be formally implicated? I mean, in other words, can Democrats continue to dance around this, or is there enough evidence now, in your view, where it's not going to go away?
I don't think there's evidence. I think there's enough suspicion, enough allegations, enough probable cause to continue an investigation. I think the key is going to be the federal judge who has to sentence Hunter Biden. I think he should refuse to accept the plea bargain, and he should call Garland and Weiss in front of him and say, look, there's a contradiction in what you said. Was there or wasn't there an investigation outside of Delaware? Did the Justice Department preclude such an investigation? If so, the bargain's off. And go back and do an investigation and come back to me where he's completed the investigation. Will he do that? I don't know. Neither party will ask him to do it. And so you'd need an organization like Judicial Watch or some other third party to come in and request that the court reject the plea bargain or at least postpone the plea bargain until we answer this question about the contradictory statements between Weiss and his boss.
Does what is alleged by the whistleblower with respect to U.S. attorney in D.C. not cooperating, asking for it to be granted special counsel status being denied. If those things are true, would that surprise you?
It would surprise me. I don't think it's something Garland would have necessarily approved of, but I want to hear the evidence. You know, I've known Garland slightly for many, many years. Always had high regard for him, and you know, when you're in the head of the Justice Department, you don't know what's going on at the lowest level. Of course, when it's the President of the United States' son, you ought to know. So I remain open-minded about this. To me, the key question that I ask Hunter Biden when he's called in front of Congress, and he will be in front of the judiciary, is, was your father sitting next to you when you wrote that outrageous and extortionate note to a Chinese businessman? Was your father sitting next to you? Did he know what you were writing? Was he aware that you were using his name? I suspect he'll say no to all of that, but who knows?
He is Alan Dershowitz, Harvard Law School professor emeritus, author most recently of Get Trump, The Threat to Civil Liberties, Due Process, and Our Constitutional Rule of Law. And you can get his podcast, The Dersh Show, on Spotify, YouTube, and iTunes. Professor Dershowitz, thank you as always. Appreciate it.
My pleasure. Thank you.
And he joined us on the Turnkey.Pro answer line.
The more you listen, the more you'll know. This is Chicago's Morning Answer. Morning Answer on AM 560. The Answer.
Hi, I'm Henry Winkler. My eyes are very important to me. My eyes connect me with things I love. I loved my late father-in-law dearly. He always lit up a room, but his vision dimmed with age. He had age-related macular degeneration, or AMD. And since partnering with Apellis, I've learned there's an advanced form of the disease called geographic atrophy, or GA. His struggle with vision loss made me want to help others know about GA's warning signs.